Hi, I'm Mark Cantor. We're at my office today at Cantor Injury Law, and today I'm going to talk to you about the 4 elements of a tort. That's the injury law. It's a civil recovery. Civil means money, criminal obviously means prison time. A tort is a remedy for for money damages resulting from an injury. So there are 4 elements to a tort in Missouri. The first is that there's a duty of care. So if it's a doctor, it's a duty not to violate the standard of care. If it's a driver, it's to drive with the highest degree of care, that degree of care that a very careful person uses under the same or similar circumstance. So they have a duty not to act recklessly, not to be unreasonable. So when they violate that duty, the doctor or the driver or the store, when you slip and fall, you say that they've breached that duty of care. The next element is causation. Did what the bad actor do cause your injuries? And I'll give you an example. If you own a piece of land and you invite people on your land and you have a tree that's been blown over in a storm and it creates a hidden dangerous condition and someone falls in that hole, in Missouri there's no liability. There's only liability for that tort if the landowner knew or should have known of that dangerous condition and failed to disclose it. So just because someone got hurt on your property doesn't mean you owe money. You got to show that they breached the duty and that it caused your injury. Another example, a better example of causation, would be if the doctors did something wrong recording in your file and then you suffered an injury that's unrelated to that. You tripped and you fell. The recording of whatever happened in your file may have been below the standard of care. They wrote it down wrong, but it had nothing to do with your tripping and falling. So that's causation. The breach of the duty needs to cause your injury. If it does, rear-end collision, driver drives into the back of your car and you're hurt, that's when we get to talk about damages. There's a lot of misconceptions about damages in Missouri law. People say, oh, I'm going to sue for millions of dollars for pain and suffering in a medical malpractice case. That doesn't happen in Missouri. In Missouri, catastrophic injury claims are capped at $774,504, $774,504. That's the most you can get, and that's if you lose multiple limbs, or you're a paraplegic or quadriplegic or have a serious brain injury. Otherwise, you're capped out at $442,574. This became a law in 2016, and the reason the number's kind of weird is that it goes up by, I think, 1.7. Yeah, it goes up by 1.7% interest each year, according to Missouri Revised Statute 538.210.8. So the point is that you're capped for medical malpractice in Missouri. Now, for economic loss, that's like your lost wages, you're not capped, but those are taxed. So good lawyers, if we reach a settlement, we call it all personal injury because everyone knows we're already paying far too much in taxes. So that's a whole nother issue for another day. If you have a real and legitimate case, Cantor Injury Law will help you prove the 4 elements of your claim: duty, breach of the duty, causation, and damages. If your case is fake or a fraud, don't call us. That's not what we're about. We're local, we're real, we're from Missouri. We're not just advertising to get your business. We're not just collecting cases and sending them out. Others send us cases. Big law firms that are advertising here now from out of state have called me and asked if we'll be a referral partner with them. At Cantor Injury Law, we're advertising, we're keeping the cases. That's what we do. We're trial lawyers. If your case is real, please call us at 314-628-9999. Thanks for watching.